that because of some tainted candidates in the list, there may be many others who could not make it to the list. Why will those candidates suffer?
Well, that
Because
exercise was
they
never
are
completed.
participating in the recruitment process, not that you are giving some benefit to them.
Age relaxation was allowed only to such candidates, categories of candidates who were appointed in the process. The parties before the Honorable Supreme Court, were persons who were likely to lose their job or who had lost their jobs. It is the orders of the Supreme Court is not at the instance of persons who were not even selected in the process.
How I can be Millard in this situation? Millard not permit. I only say that permit me to appear in the particular interview. Nothing else.
There are
nothing
so
more.
many candidates like you. You are not the single one.
Not because there is a list. Yes, there is a list. And this
And the lists are coming up in phases.
Examination in different matters.
The lists are coming in phases. There are many candidates. You are not single-handedly shutted out. Yes. Where is the direction that these candidates who participated in the 2016 recruitment process will not be permitted to participate?
That, my lord,
Where is that?
Malad, may I add something to what Mr. Bhattacharya is submitting? Malad, whenever the Honorable Supreme Court in these orders are mentioning about untainted candidates, the Honorable Supreme Court has used the words that selected and appointed, not only once.
Later on.
Yes,
Not in the
21st.
second order.
Yes, the main order has to be read, Malad. Kindly, Malad, take the main order, paragraph 3.
This is the 3rd of April's order?
3rd April's order in the writ petition at page 35. Malad, with the leave of my learned senior friend, Malad, I'm... No, but you are making submissions, so I'm sorry to just interrupt you.
Paragraph 3, you
3. Yes. Now, kindly seize who were before the Honorable Supreme Court, Madam.
Yes, I have seen.
The appellants before us are the selectees, some of whom have been working for over 5 years. They fall in two categories: selectees with purported evidence and material indicating wrongdoing, and other selectees who claim that they were validly selected and have committed no wrongdoing. The state and the commission have also challenged the impugned judgment. The respondents before us are the writ petition. Then 5. The implicated selectees have challenged the judgment on the following grounds. Therefore, the selectees were before the Honorable Supreme Court. The case of the selectees were being considered by the Honorable Supreme Court. Then, Malad, I'll come to paragraph 45 and 46. So the last question relates to the relief and whether it requires any modification. We find no valid ground or reason to interfere with the direction of the High Court that the service of tainted candidates were appointed must be terminated. They should be required to refund any salary or payment received. Since their appointments were the result of fraud, this amounts to cheating. Therefore, we see no justification to alter this direction. For candidates not specifically found to be tainted, the entire selection process has been rightly declared null and void due to egregious violations and illegalities, which violated Article 14 and 16 of the Constitution. As such, the appointments of these candidates are cancelled. Therefore, again, Malad, what the Honorable Supreme Court is considering is the fallout of the recruitment. The fallout of the recruitment, the court was not considering the consequences on waitlisted and not waitlisted candidates, mere participants. This specific question, Malad, at the cost of repetition, Malad, was considered that what the Supreme Court meant when it said untainted candidates in Arunima Paul. In the compilation, Malad, again, if I may draw your Lordship's attention, in the Arunima Paul judgment, Malad.
Please see paragraph 30 at page 169 of Arunima Paul. It is being specifically, Milord.
This point has been discussed.
Age relaxation point.
In the last order that I passed, which has been carried in appeal, if I can correctly remember what was passing through my mind, and that is there in the order also, that because of some tainted candidates in the list, there may be many others who could not make it to the list. Why will those candidates suffer?
Well, that exercise was never completed.
They are participating in the recruitment process, not that you are giving some benefit to them.
We're not saying this, that with greatest of respect, perhaps that conclusion of your Lordship is kind of facing. Your Lordship, with that entire inquiry is not yet over. And the division bench of your Lordship's court in connection with second SLST has come to a categorical finding that in such background, in our respectful reading of the judgment of the Honorable Supreme Court, what my learned friend Millard placed paragraph 49, age relaxation was allowed only to such categories of candidates who were appointed in the process. The parties before the Honorable Supreme Court, were persons who were likely to lose their job or who had lost their jobs. It is the orders of the Supreme Court is not at the instance of persons who were not even selected in the process. And our division bench, in connection with the challenge to the rules, everything at the threshold, when the rules were promulgated, on 29th, 30th of May 2025, thereafter, immediately writ petitions were presented in this honorable court. Ultimately, a division bench of this honorable court, your lordship, has innumerable times, been shown the relevant portions of the order. The relevant portion of the order, clearly, envisages that not an interpretation by the honorable division bench, and this order was also put to challenge before the honorable Supreme Court. There's no merger. It's a one-line dismissal. So therefore this order is standing, and our respectful reading of the honorable Supreme Court's order vis-a-vis the entire process, whatever was at the instance of freshers may always apply, but freshers have to come within the parameters.
Yes, certainly. The eligibility condition is there for the freshers,
And
but
it
these
is for the
candidates.
authorities to also lay down what is the possible eligibility criteria. With all humility, the court is not poised with that expertise, as to what.
No, nothing of the sort. It is only whether the benefits. Yes.
Restricted only to untainted candidates who were actually selected and appointed. That is the interpretation given, and that is what possibly Mr. Bandyopadhyay was also.
No, what I was trying to, the point I was trying to drive home was that the Honorable Supreme Court, that the Honorable Supreme Court fell short and stopped at the stage at paragraph 45 and 46 by saying that due to the egregious fraud, the recruitment process cannot be kept any longer. It has to be, entire thing has to be declared null and void. The Honorable Supreme Court did not go to the extent of saying that, look here, we have identified 6,000 to 800 tainted candidates. Let them be thrown out. And the waitlisted candidates be accommodated by so-and-so authorities. It was put to rest at the stage where the entire recruitment process was set aside. This stage did not come of accommodating the waitlisted candidates with the exclusion of the tainted candidates. Therefore, this exercise, which was taken up for the others of 26,000, OMR mismatch, etc., rank jumping, etc., that exercise was never undertaken as far as the waitlisted candidates are concerned. Therefore, after paragraph 46, what comes is that the Honorable Supreme Court says that those who are not specifically tainted should be given an age relaxation. That is at paragraph 49, which only means that those candidates who were in the foray, who were given the appointment, and not those who had no vested right. This,
Mr. Bicharchakre.
I will be only submitting because of two things. Kindly come to page 87. I say.
And I had one more submission.
When the phrase selection starts, there was the issuance of the rules. Kindly see page 87. It's kindly see the date 29th of May 2025. This rule of 2025 was adopted. Now kindly come to rule 3 at page 89. There is a note. Age relaxation in connection with fresh selection process for recruitment of candidates for the post of assistant teacher for class 9, 10, 11 and 12. Comment pertain to the directions contained in the judgment and order of the
whether you will get the benefit of this judgment.
I say, this is not the judgment, this is the rules. I am placing before my lords the rules.
The rules speak of the relaxation.
SSC has to comply.
The SSC is giving age relaxation in terms of the Supreme Court judgment.
Yes.
Do you fall within that?
Millard, I say, Millard, kindly see
The opposition stand is you don't.
Lordship has seen the first judgment. Then Millard,
Hmm.
the particular other judgment, Millard, which your Lordship have noted it. Millard, I say, Millard, kindly see paragraph.
When this is to be decided, please come.
Kindly.
Petitioner participated in the second SLST 80 2025 examination
Targetটা কি?
2025
Service Commission
in respect of classes
it is
11 and 12.
I say, Millard, with my deepest of respect, Millard, this is very disgraceful. A statutory body, Millard, takes anything. They take it that they can play fast and loose, Millard, with any matter.
Though the petitioner was issued an admit card and his name has appeared in the interview list, but thereafter he has not he or she, it's a he or a she. Acha, he has been disqualified for interview and lecture demonstration after the verification phase on the ground that he is overaged. Step. The petitioner submits that he should be given the benefit of age relaxation in terms of the direction passed by the Honorable Supreme Court on 3rd April 2025 in Civil Appeal number 4300 of 2024. Stop. Paragraph. According to the respondents, the benefit of age relaxation cannot be extended to the petitioner. Stop. Paragraph. Whether the petitioner will get the benefit of age relaxation has to be decided. Stop. Let the matter appear in the list for further hearing on 13th of January 2026. Any steps taken? Now, the candidature of the petitioner shall abide by the result of the instant writ petition. Please take this back. Otherwise, every day you all are giving me one and it's going with the briefs.
One can be kept with Millard for all.
Right.
Not once.
Next.
Your Lordship did not permit Millard, the client Millard, to appear without prejudice to rights and contempt.
No.
Your Lordship may kindly ask the School Service Commission Millard to place before the court as to whether Millard I really fall.
No, you don't. It is their stand. You have to make out a case that you fall. Did you get it?
Yes.
Otherwise, it cannot be helped.
I say, Millard, with the greatest of respect, Millard, that I have very little experience, but I say that these things, after perusing the documents, and more particularly after perusing the action of the SSC, how I can be, Millard, in this situation, Millard, not permit, I only say that permit me to appear in the particular interview. Nothing else.
There are so many candidates like you. You are not the single one.
Not because there is a list. Yes, there is a list. And
the lists are coming up in phases.
Examination in different matters.
The lists are coming in phases. There are many candidates. You are not single-handedly shutted out.